Hello, everyone, and welcome to today's discussion on the transcription of court proceedings hosted by DAKSH. We have with us today a distinguished panel of speakers to talk to us about the pros and cons of transcribing court proceedings, what the international experience has taught us, and what protocols or safeguards we might need to put into place before we go ahead and implement a system to transcribe court proceedings. First on the panel, we have Mr. Jamshed Mistry. Mr. Mistry is a litigator at the Supreme Court and the High Court of Bombay. His areas of expertise include international law, social and public interest litigation, and service law. He is also the founder of International Legal Alliance, a virtual global network of lawyers. Next, we have with us Ms. Anupama Hebbar. Ms. Hebbar is a litigator at the Karnataka High Court and a partner at the Bengaluru offices of Keystone Partners. Her areas of expertise include constitutional and administrative law, contractual disputes, breach of confidentiality, and privacy or data protection law. Lastly, we have with us today Mr. Amrish Kilachand. Mr. Kilachand is a businessman by background, but has vast experience as a litigant before various fora. Most notably, he filed an intervention application in the Supreme Court to move the court to to approve transcription services for all courtrooms across India. I welcome all our panelists to this discussion. Without further ado, let me jump right into the topic itself for today, which is the transcription of court proceedings. I think if there's one thing that the COVID-19 pandemic has taught us all is that we need to begin to embrace the use of technology more and more. Especially in the justice sector specifically, it has pushed us even further to make greater use of technology over the past few months to facilitate access to justice for litigants. And while the Supreme Court has been an advocate of using technology, whether it be in live streaming court proceedings or enabling translation of documents into vernacular languages, I think one of the areas that is yet to completely catch on and be implemented is the idea of transcribing court proceedings through the use of technology. The Supreme Court in the case of Swapnil Tripathi had, among its many recommendations, recommended the practice of allowing court proceedings to be transcribed to provide access to litigants who could not attend court proceedings for the day. This simple practice can be leveraged to bring about significant changes from the manner of presenting legal arguments to holding lawyers accountable to litigants, and even for appellate courts to use when cases go on appeal to them. It could even help judges when they go about writing their judgments or orders, and it can even help litigants who are unfamiliar with the way courts work to review the transcripts and understand what's been happening in court. It can also help journalists who report on cases and help them understand better what happened on a particular day. While manual transcription of late has largely been the norm, and its limitations are, unfortunately, as many can see, it's the limitations of the justice system itself. Traditionally, the stenographer in Indian courts takes down notes of what he or she is made to take down, but does not really record the entire proceeding itself. So what automatic transcription will help with is it will help judges, it will help lawyers, litigants see the transcript and make notes and enable them to review testimony that has happened during the court proceedings. It also allows them to focus on the proceedings itself rather than making notes to the entire proceedings. And with the advent of technology, audio and video recording of proceedings has been made much simpler. It can be even as simple as allowing a court staff to record the entire proceeding on their phone. So these recordings can then be used by several tools that are now widely available in the market to convert them into transcripts. And the quality of such transcriptions have also been seen to be quite good. It can knock off about 80 to 90% of the work that a court staff has to do in transcribing the court proceedings. And the automated transcripts can work as a first draft, which can then be amended by court staff after reading it and can then be finalized. And nowadays, a lot of video conferencing facilities are also enabling recording of the audio so that can also enable transcription. So a lot has been done on this front. So the purpose of this discussion is to know more and hear from our panel on what they think about the way forward with video transcription. So I'll first turn to Mr. Mistry, sir. The first question for you, sir, is you've been an advocate of transcription services for quite some time now. How do you think that the judges and in specific the entire justice sector can stand to gain or benefit from it?
So yeah, thank you. The justice system basically is supposed to be an open system. It is most of the courts, especially our higher courts, are supposed to be courts of record. Now, what has typically happened, at least in India, is that when you go to court, and especially as a litigator, what you realize is at the end of the day, whatever you argued in court is not sort of verbatim being captured in a court proceeding. And as you said, the stenographer only takes down what the judge tells him to take down. Now, over a period of time, that has led to a lot of issues, lots of sort of case law that you've stated in court, or arguments that you've done just don't, uh, get recorded. This is then coupled with the fact that benches keep changing. So that's another problem. And when judgments are reserved, sometimes for administrative reasons they come up maybe after 10 months, 11 months, and by which time that particular judge is completely forgotten. Yes, he or she may have made notes and all that is fine, but what has actually transpired on those days is gone. uh, I mean, I've had several, appointments as amicus, and I have to say that even from somebody's perspective who's supposed to assist the court, there is an issue, because you've sort of, by the time if you're appointed right in the beginning, it's okay. But if you sort of join the proceedings later and you're supposed to assist the court, quite often you see orders saying matter heard on so and so date, adjourned to so and so date. That's it. But what transpired in court can never be sort of brought back. And I think this is the simplest thing, is to have your speech to text, and the on an everyday basis, you have that attached to the court proceedings. Yes, we must also remember that a transcript is not an order of the court, so that is different. But it is a great tool to rely upon, and I think uh, you know uh, people have said that judges keep little diaries and notebooks, and they sort of give it to each other, and things like that. But again, that's neither here nor there. This is a very well established sort of format, which is available. And I dare say that while we were researching for this, we found that this was a common law system which was available. And in 1908, there is a judgment of the Bombay High Court which is completely transcribed, wherein there was obviously no computerization. We've seen the same thing happening even with the legislature, where they've recorded every word of what happens in whether it's the parliament, the assembly, or a a council. So that this is the process, and there's absolutely no doubt, at least in my mind, that a lot of issues that a court faces today will be taken out from it if the judges have transcription available to them.
Right. Okay, so that actually takes me to Mr. Kilachand then. So, as a litigant, how do you feel that transcripts could help litigants or even the media who report on cases that are there before the courts? How do you think they stand to benefit? And is there any situation where you feel this might not help?
Transcription, in my opinion, is absolutely mandatory, and one of the most important things that we in India require if we want to change our judicial system, because right now, the whole system is in what I call chaos, because it is so heavily overloaded right now. And so, the first thing that it does is brings in transparency and accountability. I think these 2 points are the most important for a litigant, because, after all, a litigant is going to court because he has got issues that have to be dealt with, and, troubles, and he needs to know that, the system is working properly, it's transparent, and whatever is happening in court is kept, record is kept, so that for current and even the future. And, today, for example, I'll give you a small example. You see a normal load in any court, whether it's a civil court or a criminal court, where you have, judges who have 100 matters on their board, right? And so what happens is, how does the judge determine what's going to, first of all, which matter he's going to hear, because from 9 o'clock, 10 o'clock to 5 o'clock he's in court. After that, he takes the 100 matters back home. He's got a family life. He's got all these issues that he has to deal with. And then plus he has to read papers and prioritize which matters have to be heard, because there are always 100 matters on his board, right? And then when the matter comes up in court, you have situations where, normally the opposing counsel, one of the few tricks that are normally used is to take adjournments, to take dates. So even if a matter starts getting heard, halfway down hearing, because of paucity of time and load, they adjourn the matters, and then by the next time, as Jamshed rightly said, the next time the matter comes around, which could be a couple of months down the road, either the judge has changed or lawyers have changed. So where is the continuity? I mean, how does a judge continue with a case when he doesn't have a clear record in front of him of what happened the last time and who said what? So this, according to me, is a very important thing, because it will bring in continuity into the system where, you have a flow, and also, more importantly, statements that are made by lawyers. Typically, many lawyers, either they change by the next date, or they make statements which they change by the next date. So the judge who's sitting there, even if it's the same judge, 2 months down the road, he is not going to remember what was spoken in detail, because, it's just, the system doesn't allow him to do that. So transcription would, resolve all these issues, because there is a clear record in front of him, who said what, who mentioned what. It also brings in a kind of a way of discipline, because lawyers will be careful on the statements that they make, because everything is now being recorded, and you're not going to be able to turn around the next date and try and change the statement or make alternative statements, because what you said has already been recorded. So I think these are the few issues that transcription will definitely sort out. And then also, this is the civil, then on the other side, you have a criminal justice system, in which, if you look around the courts in India today, the lower courts, there are lakhs of people languishing in prisons because of reasons such as not having a lawyer, not having representation, or their cases not coming on board. I think because, just the workload is so heavy. So, many times what you see in the criminal justice system is under trials are brought to court, they give their attendance, and then they go back, because their cases can't be heard, because there are another 200 matters that have just landed up before that judge. And he's a human being, and you cannot expect him to, what can he do? So I think, even here, a transcription system will help so much, because his case is made out, the statements, the police statements, or whatever other statements that are recorded are brought before the judge, on which basis he can pass orders, or the next time he can conclude an investigation, because already what has been said has been recorded. Another place where I think it's of great use is for people who are differently able. Today, differently able people access into a courtroom anyway is so difficult. And in court, there's so much chaos that, for them to be heard or seen, is very difficult. I mean, we find it difficult. So, people who've got issues of sight or hearing or whatever, I mean, they should also have a system where whatever has been spoken on their behalf is recorded, so that they are aware of what their litigations are, and what is going on in their matters, etc., etc. So I think these are a couple of areas where I think transcription is absolutely vital. And then of course you have all these other issues, such as increasing efficiency. As Jamshed said, today people take notes, whether it's the lawyers, junior or judges. I mean, they're wasting so much time doing this, when in reality they could have a proper document or a transcript in front of them, which just gives everything that has been spoken, and they go down to the word. So if you say from good morning till the time you conclude your statements, everything is recorded. So it makes it so much easier to conduct proper courtroom cases, and more importantly, to actually give justice to the people who are coming into the courts specifically for this. And as far as the media goes, I think the moment you have, again, transcripts and you have a recording of all the procedures and proceedings, their reporting will also change because now they have a reference point to be able to, make their news articles on, and there will be no misinformation because everything is clearly recorded. So I think that will really change a lot of because a lot of the media today you hear are making statements based on what their associates or someone has heard in a court, but they have no proper documentation, on which they can rely upon. So I think that will make a big difference also for their own reporting, and so that the news comes out more accurate, And with regard to where it may not help is, you have certain cases such as, exploitation of people, rape, divorce, I mean, these are the areas which really you can't have transcription, or you can't have it out in the public purview. I mean, that's something a system will have to be worked out for. Also, for example, cases regarding defense, army, intelligence, these are areas which are ultra sensitive. So I think the courts will have to come up with a system where you keep these cases out of the purview of, I don't know, whether transcription or whether you keep them out of the purview of being in public domain, because, being sensitive, it's something that you really wouldn't want out in the public domain. But other than that, there is no reason for transcription not to be a part of our system, which will really, really, in my opinion, it's a game changer. It will completely change the face of litigation in
Right,
India.
right. Thank you, sir. Ms. Hebbar, turning to you, like Mr. Kilachand mentioned, it's a game changer, no doubt, especially when it comes to judges, for helping them or for litigants to understand what's happening in court. But what do you think, how do you think transcripts could help a litigating lawyer like yourself? What way do you think that lawyers stand to benefit from such transcripts?
Thanks, Shruthi. So I completely agree that it's definitely something that greatly benefits the the justice delivery system and faith in the system, and definitely benefits the litigants. Now, for litigating lawyers such as myself, there are some very obvious benefits. One is, like Mr. Mistry said, a real-time record of everything that has happened in the past and in the present. This leads to, of course, greater accountability of the judges, not just to the public at large, but to lawyers, and it will also lead to better behavior, I believe. Obviously, everything is being transcribed. There will not be loose comments and maybe derogatory statements, which many lawyers face on the whole. Very obvious discrimination between someone very senior and someone very junior. These are issues that young lawyers complain of. So hopefully, given that a judge is aware that everything is being transcribed in real time, will make them self-regulate their behavior a lot more. But I also see that as a possible negative thing. I don't know if that will lead to too much self-regulation of behavior by judges, whether they will then stop telling you what's on their mind and it will become more of a monologue. I don't know. Maybe our judges, like the sound of their voice a lot. So I don't know if it will ever come to that. But that is, you can see that as a definite fallout. Some judges may not tell you. A lot of times, I'm sure Mr. Mistry will agree, there's a feedback loop. So when you're arguing and the judge is sort of thinking out loud, you take from that and you realize what kind of points are sticking with him or her and what you should concentrate on, not concentrate on. Maybe some of that will be affected, but this is just me sort of trying to fish for what could happen. It's not really, I don't see it as a big problem. Secondly, I think transcribing in lower courts. In Karnataka, of course, the original jurisdiction is with lower trial courts, not so much in Bombay and Delhi. So the way witness testimonies are recorded are an absolute mess. Sometimes it's basically the witness relaying to the judge an answer and the judge paraphrasing that answer into a complete sentence and recording it as it were a flow. That's not really how witnesses give testimony. So a real-time transcription, I think, can be a game changer in the way witness testimonies are recorded. I have seen it. I have assisted in matters where I have had real-time testimony of witnesses, and it's far better. And sometimes, in fact, in court, witnesses will give testimony in Kannada. It's paraphrased in English. A lot can be lost in translation. I've made a couple more points. this is, I mean, something slightly specific kind of comment. The other thing that happens a lot of times is even when lawyers are ready and willing to go on with matters, judges, for reasons best known to them, tend to adjourn them. So I feel it'll rein in some of the adjournments that we see. And sometimes, as it so happens, for instance, I'll give you an example. I have a matter where we've been ready to go on for, I think, a couple of years now, and the judge just adjourns it. And when we applied for an order sheet, it was noted as if we had been seeking these adjournments over a period of 2 years. So obviously that example jumped to my mind immediately, because I had to then send that to my client and explain to them that, look, I did not ask for an adjournment. And in fact, whatever is recorded here is completely opposite to the emails I have been sending my client. So I see even the faith of litigants, just like Mr. Kilachand said, that their faith in the system will improve. Hopefully their faith in their lawyers will also improve with them being able to have real-time transcripts.
Okay, so largely it looks like we're seeing more positives than the negatives at this point. But Mr. Kilachand, is there anything that we can learn from the international experience? What have other countries' experiences been in terms of those who have adopted such transcription technology?
Of course, I mean, today you have the US and Canada and UK and Australia and all these. You have Malaysia, Singapore, even Nigeria, who have got actual transcription systems in place and use it extensively. And I think one of the biggest advantages really comes down to this: transparency and a proper permanent court record, which gives you exactly what has transpired in a court of law for the current litigation as well as for future reference, right? A lot of people use cases also for future references. So in that sense, in the Western world, I mean, this is extensively used. It's used in every case, I think. And, they have court recorders now. They are actually going back to the system of court record, which is more like stenographers. And, by the end of the day, they prepare a perfect record and document, which is signed off and uploaded and in fact handed over to the concerned parties by the end of the day. So they can also use that for their next strategy for the next hearing as to what has been spoken, what they need to do, the lawyers, the clients, everybody. So in the West, it's a part of the norm. It's used on a daily basis in every case. And I think that makes a huge, huge difference. And, what they also do is, I think, for people who are under legal aid and criminal litigation, transcripts are given free. But otherwise, you've got to pay a nominal charge for buying a transcript, right? And I think what also could be used in India, which is that, you have a revenue model created around this. So like they do in the West, so that the costs come down. So, there it's completely accepted as a way of life. I mean, in fact, people get surprised when they hear from us, you don't have a system in place of transcription, so how do you all function? I mean, we've had people ask us this. So it really shows for them, it's the norm. So, and as Jamshed rightly pointed out, strangely, from the early 1900s in India, in Mumbai, the Bombay High Court, there's a very famous trial, the Tilak trial, Lokmanya Tilak, Bal Gangadhar Tilak, and 1908, and there is a transcription that you can pull out even today if you Google it. So can you imagine that we actually had all these systems in place, right? And we were doing transcription. I don't know where and how it went off the horizon in India, but it was there as far back as 1908. So, it's something that really deserves merit that we actually had this in place. But abroad, it's absolutely standard.
Right. Going to you, Ms. Hebbar, considering what Mr. Kilachand just said, in Western countries, it appears that transcription is more or less the norm. But if we were to do something similar in India, what do you think the legal framework should look like, especially for lawyers and litigants? And is there any safeguards that we should have in place to ensure that privacy is protected? Because clearly there are some cases of sensitive nature where we may not want the transcripts to be put out in public domain. So, what would you think that the legal framework should be?
On this, actually, like I have a few thoughts on what the high level concern should be when you're making up a legal framework. I obviously don't know the right answer. I don't have enough data to understand what will work and what will not work. But there are some high level points as to what are the kind of issues that we are going to be looking at when we consider a legal framework. Now, of course, the first will be what will be transcribed. Like Mr. Kilachand was saying, there will definitely be cases that may not, should not be transcribed, that are very sensitive in nature, that involve rape victims, child witnesses, things like that, and official secrets. Now, you will obviously have to determine if there is a bucket of cases that where you can disable transcription altogether, or should you be transcribing everything and in fact controlling access to such transcription. So that's the first question, because both of them play into each other. Because the more sort of buckets you create where transcription itself can be disabled, you're sort of losing the plot. Instead, a very strict control on access can serve the very same purpose. You can also achieve it by, redacting names and removing whatever part of the information is sensitive. Now, second, obviously, will be how will you ensure accuracy of something like this? When you're looking at a legal regulatory framework, you need to ensure that the technology you're using, because the more you start putting it out there, the more people will come to rely on it. When you are relying on it, you don't want to be running behind figuring out whether it's accurate or not. So what kind of technology you will use, what will be the minimum standards you need. Secondly, what level of manual oversight is needed to determine this technology's accuracy. You will also obviously have to then make some other procedural law changes to ensure reliability of these proceedings. As both Mr. Mistry and Mr. Kilachand was saying, if you are going to be relying on these proceedings in subsequent proceedings, or you're going to be relying on it for the process of appeal, accuracy becomes crucial to determining how reliable these proceedings will be when you start to use them in a real life context. Second, then coming from these two, obviously will be the powers of the judge or the presiding officer himself or herself in this matrix, whether they have the right to determine what will be transcribed, whether they have the right to determine or to overrule any request to either transcribe or refrain from transcription. Should people have the ability to appeal such a decision? If the judges doubt the accuracy of a transcription, should they be allowed to have oversight on it? Should they be allowed to suggest corrections? Should there be a time limit? So these are the various issues that comes in relation to the power of the presiding officer himself or herself to control the proceeding. Then, of course, the most important, how will you regulate access to these transcription proceedings? Now, without a doubt, matters involving constitutional importance, your triple talaq, Ayodhya, all of those should be ideally open to everyone, should be put up on the website maybe and for view to everyone, because this is something that governs us all. And it's closer to transcribing legislative proceedings, for instance. But what about private disputes? Now, because I've done some fair bit of advice in relation to data privacy, privacy is not so simple in itself, because it's not a question of having a sensitive matter. Say I have a commercial dispute with someone, and in that commercial dispute, a lot of factors about how I run my business come to fore. Now, each piece of information in and of itself may not be that relevant, but put together, it forms a kind of picture and image of who I am, what I'm doing, what my business is, etc. So there is data protection laws are evolving, and understanding privacy is evolving to recognize that this itself is a right, because most, the way data is governed, most require a level of anonymization, which obviously a transcript may not be able to provide. Hence, it's very important in a private list, how you control access. Maybe it's only given to parties. to councils or to any third parties who can show that they have some form of interest in the transcription, much like how orders and certified copies are regulated now. Of course, private lists can also become of public importance, because if an important question of law is answered in it, then maybe with consent you can consider making it public, etc. But to me, this controlling access is very, very crucial in determining how private or public this information becomes. How the right of privacy will be governed in this matrix will be through control of access, in my opinion. Now, of course, you can split up transcriptions even by court. Like the higher courts have transcription services, whereas the lower courts may not. Certain tribunals may have, certain tribunals may not. Then obviously next is the cost. Who bears the cost? As Mr. Kilachand said, my thoughts were the same, that in case litigants are not able to pay for it, or in certain important instances it can be made free. But otherwise, the cost will likely have to be passed on to parties, because frankly, I mean, we're doing video conferencing hearings and most courts don't even have paid video conferencing accounts. So I really don't see practically speaking, where the cost for this is going to come from. And last, again, a facet of privacy, destruction of records. How long will you be keeping these records for? Maybe 30 years, which is usually standard. Do litigants have a right to have these rights struck off? Because this is also another right in the area of privacy that's developing, which is called the right to be forgotten. So as part of that right, maybe you also have the right to have every proceeding struck off. So these are, in my opinion, the broad framework of what any law that regulates this comprehensively should look like.
That's helpful. That's helpful to know, because I think one of the first steps would be to figure out a legal framework before going ahead with implementing such technology. With that, I circle back to you, Mr. Mistry. I have a two-part question. The first part is, while Ms. Hebbar just spoke about the legal framework and what it should look like, how do you think this should play out in practice? How do we go about implementing such technology? Do you think maybe we should start with some pilot projects, perhaps pilots in the trial courts, or maybe the Supreme Court, because it eliminates some of the problems of maybe vernacular languages? So how do you think we should go on to implement such technology? That's the first. The second one is clearly, like Ms. Hebbar again pointed out, and Mr. Kilachand as well, there are concerns about costs, and there are also other concerns about how effective such technology may be, and more so with respect to trial courts, where some part of the proceedings can be in the local vernacular languages. So how do you think we can overcome these factors? What are your thoughts on this?
So as my good friend Amrish very rightly said, see, across, we are not developing something that for the first time. This technology and everything has happened. I mean, it is played out for years on end. I mean, one of the best examples of transcription and as well as live streaming, etc., is take the International Court of Justice. I mean, it's fabulous how they've perfected this art. So typically there, what happens is your every day's proceeding is recorded. The transcript is available not only to the litigant, the parties, but to the public at large. Of course, yes, these are matters involving two states, and therefore, but the concept is fantastic. So that is available to you. The second thing is you get an instant translation, which is also a problem that we have in India, especially because up to it's only in the High Court and Supreme Court that English is the the official language. Lower court, what happens? So these are very, very easily sort of adaptable. You click on it and you get it. So this is one aspect. I think with regard to how it, first and foremost, you will need to, because every single country that we've looked at have had very detailed rules and regulations. Okay? So what is involved? It's virtually like an act which sort of describes each electronic term, what it means, so it's in very, very great detail. I think we can happily adapt to any of these systems. Singapore, Canada, I believe even China has it. So all that is available. So there's no problem on from the the legislative or the regulation aspect as well. Uh, where should it start from? I think I'm going to give you a very different answer. I think it should start from a moot court. It should start from law school. Okay, that's where it should really start from. Let the next generation really get used to the system. And as far as the courts are concerned, it's very, very easy. What you do is, and because what is it? You're just simple, you don't even need the video. Okay, which, I mean, some people have, they say, no, video is offensive and we don't like to be seen and live streaming. But even that is over. That's history now. The Supreme Court has said that in certain cases, live streaming is a must. And if you've heard, the E-committee and everyone is saying that, or we're probably going to get a sort of a hybrid system. So yes, you are going to be seen, arguing your cases. So you might as well get used to it. So that part is not much of a problem. And yes, so what happens typically is you record the audio, and that audio then gets automatically transcribed. And it's there are I mean, that there are readily available apps for that. Of course, I think what the court will have to do is, for the entire nation, they will have to bring about a system which is then accessible to all, from the lowest court to the Supreme Court. And I think, and one thing that I've always said about technology, it takes no time to implement at all. So if you want to, start with transcription, I think you can implement it throughout the country in a month's time. It's as simple as that. So there's no difficulty. You will, yes, your whole pool of great stenographers that we have today can certainly be trained. The accuracy of apps are also now excellent. So, that's not much of a problem. I mean, I've done, in an experiment, I have sat down and transcribed myself, and it's amazing. You get about 85 to 90% accuracy in something. And I'm not a extremely technologically savvy lawyer, no. So it's simple, and I think the faster we implement it, then the better it is for all concerned. I just take one more minute to answer Anupama's question on the concerns of lawyers, litigants, and on judges on the privacy issue. I think even those have been beautifully taken care of. I mean, I'm very familiar with what they do in Canada. If it is a private case, it is only the parties that get copies. You have to apply for it. That's the important thing. So and the transcript actually every day, just as they review their orders, they review the transcripts also. And in India, yes, we would have sometimes because of the use of language, a little bit of training perhaps is required on that front for accuracy, but otherwise I don't see it as a problem at all. And I've always said, the faster we get on with it, the better it is. It's going to clean up our system completely.
Right. That's very encouraging to know, sir. So if internationally also it's being done, and they figured out clearly some ways to work around some of the concerns that I think all of us have with regard to having these transcripts put out in public or even recording them themselves. So I think it's a good way for us to learn and build on what we've already found out from the experiences of others. Before we wind up this discussion, I just like to go around to just see if anyone has any closing remarks to make. So maybe I'll start with Mr. Kilachand. Any closing final remarks, sir?
Well, as Jamshed rightly said, the sooner we get onto this, the better it is for everybody. And, I think there is a great need to bring in transparency and accountability into the judiciary. And I think for all the stakeholders, whether they're litigants or lawyers or judges, I think this is going to be an invaluable tool for everyone concerned to not only increase the efficiency, but then again coming down is the accountability. I think, one of the things in our judiciary that's kind of missing a lot is transparency and accountability. And I think this will just make it's a complete game changer. And I think, in a couple of years, you will see a lot of frivolous litigations, a lot of misuse of the judiciary completely disappear. And I think that's the need of the hour.
Right. Ms. Hebbar, any closing comments?
Not much really. I think everything's been covered. The only thing, obviously I'd much rather read a transcript than a Twitter thread. So which is what is happening now really. If you want live, if you want to know what's happening in court, some people who you follow on Twitter, that's about it. So yeah, like he said, better get on with it. It's already happening.
For sure. Mr. Mistry?
Yeah, I completely agree. And I think, following someone on Twitter and getting live updates is absolutely not the real thing, because you are getting somebody else's version or view of what is happening in court. And I think they just need to, yes, importantly, therefore this has to come from Supreme Court down. The entire law has to change on this subject. Although they have, if you read Swapnil Tripaঠি's matters and the fact that our interventions have been fully allowed, it would mean that yes, this is something that the Supreme Court has accepted. And of course, I think the other, the important aspect is, which we've not really spoken about, is that this is the least, from a lawyer's perspective, the least offensive, because this is not video. You don't, so you should actually start with this, in my opinion, immediately. You can get into the video recording at any given point of time, but this can be done instantly. I mean, there is, in my view, no reason why this is not happening. And since it is, the government also is absolutely okay with it, because their proceedings in the legislature are recorded, so they're quite used to it.
Right, like you mentioned, sir, that's true. The Supreme Court's blessing has, in that sense, come through already for having these transcripts in place. With that, I'd like to thank all our panelists for joining us for this discussion today and taking some time out to be a part of this discussion. And I surely hope that we see more progress on this front, and hopefully see all the courts beginning to implement the transcription of court proceedings. Thank you all for joining us again. Have a good day. Thank you.